Good afternoon or good morning for some of us. Welcome to our webinar today. My name is Alexandre. I'm the Executive Director of EU DisinfoLab, and on behalf of the whole EU DisinfoLab team, welcome to our webinar today, which is called Enforce on the DSA Enforcers. How can member states legally push the Commission to act? Before we start the webinar, the usual housekeeping and reminder, we are from EU DisinfoLab. EU DisinfoLab is a non-profit organization gathering knowledge and expertise on disinformation in Europe. We organize these webinars to give voice to experts and for our community to be able to have access to experts, to ask questions, to share knowledge, and to raise awareness around the excellent work being done by many of the community members on Europe and beyond. First, a quick reminder, it's still time to grab your ticket for the EU DisinfoLab conference, Disinfo 2026, which will take place this year in Vilnius, Lithuania, on 7 and 8 October. If you want to join us for the conference, the website is very simple, disinfo.eu/conference, and it's the perfect opportunity to grab your ticket. We'll announce the first speakers and the first sessions in just a few weeks. Thanks again to everybody that has been providing excellent things. In terms of housekeeping, this webinar will be in English. If you have trouble understanding my French accent, or if you would like to have more capacity to look into your own language, we have captions available. To do so, you go on the top-down menu on Zoom on captions, and you can check the language and put your own translated captions, language preferred there. On another thing, we're going to take questions not using Zoom today, but using slido.com/disinfo. If you put questions on Zoom, we won't see them, so please use slido.com/#disinfo. You can join us by using the QR code. I'm going to ask you a first question and to see how many people are joining today. Where are you joining us from today? And we already have people typing from Brussels. We're already around the corner. Madrid, Helsinki, Germany. Interesting to see, Christine, that we have already people from different member states, people from Paris that are still celebrating the Champions League final. Okay, excellent, thank you. And we have already quite a good crowd. Also help us to tell us which sector do you represent today. So we have a bit of an overview of where you are calling from, people from EU institutions, academia, other NGO, civil society. Okay, quite a diverse, not so diverse with civil society around. Great. This webinar is recorded and will be also made available on our YouTube channel afterwards. The topic of today is part of our evidence and enforcement series. And as you know, EU DisinfoLab has decided to focus more on the missing enforcement mechanisms around European regulation, including, of course, the DSA, the Digital Services Act. In the past month, many member states, many civil society organizations have expressed concerns over the enforcement, or more accurately, the feeling of the lack of enforcement of the DSA and the DMA, the Digital Market Acts. While the X company was fined last year, there is still no transparency over the financial guarantees Higgs has provided to the European Commission, which is a key element of the fine. In the same proceedings, the European Ombudsman concluded that the European Commission had committed maladministration by refusing to be transparent about X's systemic risk assessment reports under the DSA. Additionally, last month, journalists from Handelsblatt reported that a fine against Google, which I quote, in the billions for the DMA infringement, had allegedly been postponed by the President of the European Commission herself. These events, combined with the lack of transparency on current proceedings, have prompted us at EU DisinfoLab to ask the following question. If the European Commission can open infringement procedures against member states when they are not implementing the EU law, what could member states do to force the Commission to act when it falls within its responsibility to enforce primary and secondary European law? Can member states enforce on the enforcers? To discuss this very important topic today, I'm pleased to be joined by Christine Allan de Lavenne, an American and French emerging technologies legal and policy advisor. She's a French licensed attorney focused on EU technology regulation, digital law, IP, and media law. She's a founder of Side Law Office, a cross-border practice based in Paris and Silicon Valley. Christine, you've been helping and around DisinfoLab for a few years now, and some of our committee members might remember you from the different sessions you attended at the conferences. And I can announce that you will also be there with us this year in Vilnius. So, Christine, the floor is yours. How can member states legally push the enforcers and the Commission to act? Thank you.
Thank you, Alexandre. Hello, everybody. Very nice to have everyone today to discuss this important topic. Again, thank you so much for having me. So I'll try to, at this point, describe a little bit where we are and open for questions on how to enforce the DSA in a more efficient way. Let me first start with my slides, if I can get it started, and I can, I'm sure. There you go. So now, I'm sorry. This is just, it was working a minute ago. There we are. There we are. There we are.
All
so,
good.
Do you see everybody who sees my screen? Everything's good, Alexandre?
Yes, it's perfect. Thank you,
All right,
Christine.
perfect. Sorry for the little technical issue. So, yes, the question we are asking ourselves today is where we stand in the enforcement of the DSA. I think we are really at a important moment. We're at the crossroads of the first wave of enforcement and looking at the future of enforcement with some improvements along the way. So the question I have been asked to look into is mostly how member states can improve the enforcement and can participate in that effort, but I will go through a little bit of other aspects as well of the enforcement to give you a general picture. So I will first look at where we stand. So where we stand right now, it's important to look at, okay, we are 3 years in the enforcement process. How many decisions, what decisions have focused on, and what are the malfunctions that we see coming out of this? So in terms of Commission decisions, there are 5 main actually, some of them are commitments and others are decisions, but 5 main cases that have arose over the past years, 2 resulting in fines that everybody is well aware of against X and Temu recently, and then 3 of them that have resulted in commitments from the platforms. Commitments meaning that it did not result in a final non-compliance decision, but in some raising the attention of the platform that actually took action on it, and that was approved by the Commission as a satisfactory response. What's interesting here in the formal decisions is that we see that a couple of them focus on researcher access to data. So that is going to be an interesting piece, of course, of the enforcement, as it is key for everybody's work here. When it comes to what is ongoing, right now we have a few preliminary findings and ongoing proceedings that actually concern pretty much the same players. We're back with AliExpress, TikTok, Temu, and now Meta. AliExpress is pretty advanced. It will likely result in a non-compliance decision, but it's still ongoing. The other ones might result in commitments because there has been active procedures or actions proposed by the platforms. What we see here again is that there is more focus again on 4012 or 40, which is the article of the DSA that grants researcher access to data in different forms. So this is something pretty substantial to follow, as it will give some contours to the whole notion and interpretation of Article 40. Now, how have the VLOPs countered the current action? I think that's very interesting to see where they fight back. and where things are likely to change. Again, the lines of interpretation of the DSA. We have a few decisions that the VLOPs have introduced. Zalando and Amazon were amongst the first. Those challenges were focused on VLOP designation, and that is interesting because it really set the threshold really high, or the bar pretty high on the designation of a platform as a VLOP. So they have tried to push back on different arguments that were all rejected. So I think this is fundamental to see that the Commission is upholding the strict criterias for VLOP designation and that the pushback from the platform has not been successful. The one that the platforms have actually won is, I would say, pretty minor because it concerns some procedural grounds. It's more about the methodology used to establish the fees and not the fees themselves for Article 43. So it's a win, but it's not the most significant one, and it doesn't have much impact on the interpretation of the DSA. The one that everybody has the eyes on is the one pending actually on behalf of X. And this one has a lot of impact on how we will interpret the DSA in the future as it concerns some of its main provisions. And it will be also the first one that will actually test the Commission on the setting of the amount of the fine. So it will be a landmark decision to follow, and it is pending. Now, I think very much more in a much more interesting way, it's important to look at what is happening in the national courts, because you have the European process, but really what's happening in the national court is really interesting. So many NGO players, amongst some of you, I'm sure, have taken action before national courts, mostly in Germany and in the Netherlands, and you will see them here on this slide. What strikes us in looking at the national court decisions right now is that they have pretty much all, except one, been on the ground of Article 4012. So they have been at the initiatives of researchers, and they have been intended to better define and expand the interpretation of 4012 to grant access to researchers. All of these cases, except one, which was on the matter of urgency, again, not very relevant, but all of them have been won by the researchers, and they mark a really important step as being the first successful private DSA enforcement actions. And we can see that they're actually also pretty quick in the way they have been addressed if you look at the dates here. The last one of February in Germany is particularly interesting in that it is groundbreaking in setting a cross-border enforcement setting for the researchers, meaning researchers can sue the platforms at the location of their research, not necessarily where the platform has its headquarters. So X was ordered to provide data on Hungarian parliamentary elections before the German court. Now, after all these 3 years experience, which is pretty short, and in the history of emerging technology regulation, which I have been working in the field of and observing for over 20 years, the level of enforcement of the DSA is actually pretty strikingly high compared to other regulatory instruments in the past, meaning there has been a lot of action taken in the past 3 years. So it's not so much of how much we can enforce more, I think. It's more how can we enforce better. That would make a little more sense if we look at the perspectives we have so at this point. So it has, over the 3 years, shown a few malfunctions that we definitely need to address, and there are different players that have particular roles in each of those fields. So the first one that we see commonly come back to us is that the researchers don't have enough guidelines, or the guidelines are too vague from the Commission on the way researchers access and have to apply for access and risk reporting don't have the binding minimums that are necessary to really actually be efficient. So this is something that and rejections also happen without any justifications and in delays that are, irrelevant. So this is something that can be fixed by the commission, and it is no surprise because we're in the first stages of enforcement. So it is normal that we need some adjustment there, but there definitely needs to be better standards with binding minimums and strict timelines and more clarity on the rejection grounds, etc., around Article 44, which is the role of the commission for this. Another aspect, which a lot of you, I'm sure, will agree, can be really considered as broken or needs to be really fixed in a more substantial way, is the data access process, the famous Article 40. A lot of you are acknowledging lengthy delays on the decisions, and none of you researchers around have appeal rights on whether the platform addresses or not your demand. This is really something that I feel needs regulatory reform and changing specifically the appeal rights. For the time being, only the platforms can appeal, and they can also choose their own mediator, which seems to create some asymmetry that needs probably to be addressed. The same way as probably something as regards interim access, so meaning when decisions are pending, sometimes there are some matters that are urgent because we're addressing electoral processes or immediate disinformation dangers and risks. So there needs to be some form of interim access there. The third form of malfunction that we've acknowledged is that the DCS are the designated coordinators are underused or underpowered. So it's variable depending on the states. But what has happened is we see that some of them are very active, some of them are not at all. And some of them are at this point still not empowered with the actual legal authority, sanction authority, and mechanisms to even sometimes just vet the researchers. So some countries have DSCs that currently do not allow the researchers to actually put in an application because they don't even have the vetting authority. So we'll go into this a little bit more in the future slides. Of course, a general malfunction, but I don't know really how to address that one other than with stronger political will. But there are obviously some geopolitical interference and pressures. A lot of you have commented on the US pressure recently on the fine that was sentenced to X after all these discussions on trade influence. I mean, it's bound to happen. There has always been political interference on regulation and application, but there needs to be at least some light put on this and maybe some transparency brought onto how we consider interference really as a rule of law concern. Then the last point of malfunction that is widespread as well is that in the application of 4012, we are at 49 applications only. This results from the latest roundtable that was organized by the European institutions, and this is the latest data we have, which is considerably low given the need for the enforcement. And it really stigmatizes some construction gaps that need to be better addressed in different ways. One is probably the quality of application in many cases could be improved when we consider the whole process as a legal process, really. But that kind of matches what I just said in item number 1. There needs to be also better guidelines and stricter frameworks. Then the second thing is, and that is a part that is crucially missing and is critical, is documenting and publicizing the rejections. Because we need to learn from our mistakes or from the misuses or from the challenges that we're facing. And then, as we saw in my previous slides, The national court system works pretty well. So using the national recourse is an effective way to actually improve what the civil society part of the enforcement can do. But we are mostly, so, oh, yes, well, I wanted to talk a little bit more about what was broken in Article 40, but I think I've kind of touched upon it already. Just quickly, but I'm sure a lot of you around are familiar with this already. The waiting period is excessive in many cases. What's interesting is that the rejection criteria, a lot of the criteria, see, on the first published rejection, it failed by 5 of 7 criteria, which really shows that there's a lack of both guidance and implementation of the application criteria. So I touched upon the researcher's appeal rights. I think that's obviously something to be addressed. Article 13, for the time being, does not allow researchers to appeal, and the platform have full sovereignty on designating the mediator. So here I've laid down a few ideas of what a fast track mechanism could imply. So the dispute, as we mentioned, and I think I've touched upon pretty much everything else. So we're really here to talk about what member states can do. So I would like to emphasize on this part maybe 4 different things that member states can do to improve the DSA enforcement. So as I mentioned a little earlier, the coordinators remain really underfunded, some of them passive, and in some cases they have completely failed at this point to give full vetting powers to the coordinators. So that's the case of these countries here that need to be more proactive on the powers they give to their coordinators, but it is under scrutiny of the European institutions and hopefully will be advancing. Now, what the coordinators all need, obviously, is the legal vetting power, but they also need an active sanctioning authority. Otherwise, the mechanism does not make much sense. Technical capacity, of course, is going to be, different on each country. The budget allocation also, but there needs to be, it needs to make sense. The member states needs to fund the coordinators at the level of the DSA demands. So this is one point that the member states can look into to make sure that their coordinators meet those criteria. Now, another aspect would be to work a little bit more closely with Working Group 4 for those who are not actively really involved with Working Group 4. Working Group 4, as many of you might know, is one of the working groups of the whole regulation system, enforcement system. It is a coordination forum that allows to coordinate, like share evidence, risk assessment, and share positions, platform positions. It's really an area where there could be more interaction in preparing the applications, addressing the applications, and countering some of the challenges. And that's important because, as we know, the working groups report back to the Commission and can stigmatize some enforcement priorities and risk standards to be addressed. So currently, what is not really working well within the working group, maybe there is someone out here who can give us more insight on how it is playing out technically, but really the participation is uneven. This is the feedback we are getting. It is more informative than operational. There's less work done. It is more perceived as a place where we just exchange ideas rather than work on the quality of evidence or get the researchers to coordinate some efforts. To work more efficiently, it would be really to focus the work on evidence, the quality and quantity of evidence, and working really on specific cases and risk categories rather than general concerns. I think it would be a good place also to coordinate action under 45, so to take out more actions together and collectively, and obviously to just improve in general the quality and quantity of applications. Now, obviously, member states are also very uneven in how active they have engaged in the DSA enforcement at their own national level and broadly. We have really active players. Some are actually missing. I apologize here because Germany should be in this list, and many, Italy also, and many others. But just highlighting a few countries that have been really proactive in raising flags and bringing attention to enforcement and actively engaging in private enforcement, which we will touch upon in a little bit. Yes, so I think that is another field where there could be some more efforts. Now, the other thing, and I think you will have understand at this point that I'm really in favor of this approach because I think it has a lot of benefits, is encouraging the use of national courts. National courts go a lot faster than addressing it through a formal European institution process. It is easier for researchers and NGOs to use, obviously no European institution needed, and it has proven, as I have told you before, to be efficient in pretty rapid also in the way of addressing the problems. Now, who can litigate? Obviously, civil society, vetted researchers, and journalists, but the coordinators also can address, can actually initiate and support proceedings. So this is definitely a way to look into more actively. Now, last recourse, of course, would be if there is in the treaty, a provision that obviously allows member states to take action against European institutions if they fail to sufficiently to take action on a clear obligation to act that they might have. This is called the action for failure to act. It is set in the treaty under Article 265. And it enables any member state to take action on, let's say, in this case, the European Commission, if it fails to act upon a sufficiently clear obligation to act. Now, let's play this out in the case of the DSA and see how realistic it is, but also what benefits we could draw of it, even if we don't put it through completely. So a member state would have to call on the Commission to open a DSA enforcement action in writing and specific and actionable. If the Commission remains silent, then it goes to the General Court. And then the General Court can decide whether there is failure to act or not, but can't substitute decision for the Commission. So you'll already see here there are a lot of caveats and loopholes that need to, or that not necessarily fit the DSA context. What really doesn't fit from the get-go is that it is pretty unclear that or pretty sure that in fact the Commission does not have a legal duty to open or pursue enforcement proceedings. It has supervisory power, but it involves discretionary power. It doesn't have the obligation to take action on all the VLOPs at the same time and have a full scope enforcement obligation. The obligation must be specific and a default to act, a silence, a non-action needs to constitute a legal breach. And that's why instead of looking at how the Commission enforces and opens proceedings, it's better to focus attention on specific proceedings such as deadlines that are let go. Say the plan of action of X's deadline passes and no action is taken. That's a clear, more objective post-decision inaction that would more likely qualify for this procedure. Now, there's a big loophole as well where the Commission can just respond in any way, including with the means of a refusal, and that would close the procedure. The only way the procedure can go to General Court is if the Commission remains silent for 2 months. So, realistically, this procedure exists. It's there if things get really bad in the future years, but it doesn't really apply in the current context of the DSA. First of all, because we are only 3 years in. Secondly, because the obligations of the commissions are discretionary. But there are ways of leveraging also this in a different way. Maybe looking at post-decision actions, as I said, is a way of address or of looking at this. Um, Looking at collective scrutiny from member states and gathering information together to have more political weight, obviously, is a good way of doing it as well. But what we've seen in the history of the use of this proceeding in action, it has rarely, very rarely, come to a final decision because it has, again, very rarely, but it has worked in just threatening of using the tool. And that has led to some action of the institutions when they were kind of put on the stand of not having done enough. So more than acting legally upon the commission and using this procedure that has many holes in the racket, as we say in French, it is better to look at it as a way of like maybe gathering scrutiny from member states in a more collective way and raising attention of the commission on the failures that are acknowledged. Now, where we go on the next steps, everybody has eyes on the action plan of X, which should be coming out anytime soon. And this will be definitely a big piece to see how the DSA is interpreted in other aspects that haven't been addressed so far. The researcher access is a big part of this, as much as the deceptive design component. Now, how regulation and the DSA enforcement will go from now on. Clearly, it calls for some operational simplification. I think the focus now will not be on new obligations, but on more focus on the investigation powers and the cross-border evidence bringing. So making the rules more enforceable rather than changing the rules. And that goes along with what I said about looking back onto Article 13 and the right of appeal of researchers, just as much as reinforcing the guidelines and making things more efficient in the collaboration aspect, namely in work group 4. We've all seen a strong convergence in between the platform's digital trust regulation and the AI regulation. The omnibus is one of the pieces to keep eyes on, as it will make some convergence in between disinformation and AI generated disinformation. So this is kind of the first elements to discuss, and I am happy to take all the questions. I hope there are many out there, and maybe some insight also on operational playouts. Thank you very much for your attention.
Thanks a lot, Christine, for this really, really excellent overview of the current challenges and cases. I think it's very, very informative, and we're going now to the questions. So if you have any questions, reminder, we'll take them through slido.com, #disinfo. You can scan the QR code or go on the website. We already have 7 questions, Christine, so I think we'll have time to address everything today. First question, provocative question. Is it realistically possible for the Commission, as an avowedly political body, to be a reliable, independent enforcement agency?
All right. Well,
I think there are precedent about antitrust, DMA, and I think the Commission has quite some experience into that kind of enforcement.
I agree. I think international law in general and international institution regulation comes with the variables of political influence always. The question is how we keep a healthy distance with political influence rather than trying to be oblivious of it. There's no black and white. It's really in the middle. And I think the Commission and the European institutions have taken that pretty seriously. There's been a lot of signals recently of standing also as a strong, you mentioned independent. I want to say strong or sturdy political body. Let's hope it continues in that way. But does it have the ability to? Yes, we have tools in Europe to make sure that there is independence in the way institutions are addressing enforcement.
And I think to add on that, it's also about our relationship as, for instance, civil society organizations to the institutions to hold them accountable and to actually not to put pressure on making sure that we have transparency on the decisions, we have transparency on how the decisions are taken, and on the consequences. And that's where the enforcement goes not only into making sure that the law is enforced, but also to have a permanent pressure to make sure that the institutions are delivering what the regulation is meant for, and to, as we mentioned very much in Brussels, that the European Commission is the guardian of the treaty. So it's also here
Yes,
to make sure
and
fundamental
and
rights are being.
to go to your point, Alexandre, this is why I wanted to emphasize the need for more documentation and publication of the rejection cases and more scrutiny on where it doesn't work. If we don't like bring light, constructive light, on what doesn't happen or doesn't work, I'm sorry, where it's not changes is not likely to happen.
Yeah. Thank you. We're going to go to Ali McBeal, another lawyer. If national courts can recognize the DSA infringement at national level by VLOPs, I think that's the bits of freedom case. Shouldn't the European Commission be forced to open proceedings at the EU level, as VLOPs regulations is the Commission's role? I think Commission has a specific role around VLOP regulation.
Well, this is kind of like looking at the problem by two angles. The enforcement of the DSA is a joint effort. Everybody has a role to play. The European Commission, national member states, and the civil society. So, uh, as long as the problem, the infringement or the breach of obligations of the VLOP is addressed, I don't know why it should be necessarily addressed by both of the enforcement authorities. It should be done in cooperation. So evidently, evidence should be shared, collective knowledge. There should be a joint effort, but there is no sense in opening two proceedings at the same time. That would create lengthy proceedings, conflict of interpretation. And that would kind of be deterrent to the national authorities and national courts to actually step in and do their part of the job in full independence as well. So I think you can't elude one or the other. So it's my point is not to not blame the EC or blame the national countries, the national courts, but it's a joint effort. So as long as there's cooperation, I think and we are addressing the problem one way or the other. I think it is a win.
Yeah, keeping in mind that I think that we mentioned it, like national courts could also deliver orders that are only available
Yeah,
at national level, which
yeah.
also creates a de facto discrimination between EU citizens that are under the same regulation don't have the same rights. So I think that's where there is a pressure for the Commission to make sure that the regulation is applied the same way for all Europeans.
Well, the latest proceedings and decisions have defined that researchers can ask for data from any European country under any jurisdiction. So that's a groundbreaking decision. That's the latest one that really opens the way for acting upon your own jurisdiction to get data from all jurisdictions. So that's a big step, and that goes a lot faster than actually using the EC proceedings. Now also when you look at the convergence, and I can go back to the slide there of the national courts and the commission proceedings, they kind of also all concern the same platforms. We're all talking about the same players again. So there is some kind of convergence also in between what national courts are addressing and what the EC is addressing as well, as a VLOP proceeding from the EC perspective. And you can see that there is some kind of also continuity, right? So even if some non-compliance decisions have been issued or commitments have been validated, the commission continues the investigation, and that investigation is also taken, or some of that part of the investigation is also taken to the national level by researchers in civil society. So it's a puzzle game. And I think there needs to be maybe more clarity, and I agree to the question of Ali McBill, more clarity on who's responsible for what and how we can make those efforts make better sense and not conflict. But it's not a question of blaming one or the other.
Yeah. Just to stay with Ali McBeal, and then I think we're done with her. Can national court pronounce the same fines that the ones foreseen in the DSA?
They can't, well, they could technically, yes. I mean, they could define the fines they want. They're probably looking at different aspects, so it's not the same amounts we would be talking about. Though, let me see. Yeah, no, because it's more specific to, well, so far the national courts, as I said, have been addressing the researcher access
Or recommend
infringement.
the systems in the case of bits of freedom,
Yes, yes, yes.
which
Um,
which is more like a market issue somehow.
yes. I mean, technically, yes, they could define the
Yeah,
fines they want, you
yeah.
know. I think
But they could use this
operationally,
as a they could use this as a reference for defining the fine. It's like if the
that's a
regulations
much better idea, Alexandre. Yes, yes.
if the DSA says I can go up to 6% for infringement of the DSA, I'm saying this in my jurisdiction. My jurisdiction is I don't know 5% of the European territory or population, so I can apply a maximum of 5% of that 6%. I don't know, something like this.
Yes, there's always an appreciation of the damage also and the actual harm in national courts that will be kind of something to play with, and that may create variables. But again, it has to be part of the same puzzle. So whatever the national courts find needs to be used by the EC to address the general problem or the defined fines and vice versa. Yeah.
Okay, thank you. To stay on the issue of how can we make using national courts for enforcing the DSA more accessible for the general public due to the financial and economic barriers involved for private individuals and civil rights groups?
That's a very good question, and a very important one, which goes way beyond the boundaries of the DSA only. It's a general issue in Europe and broadly. Um, I don't have a direct answer to this because it would imply a lot of judicial system reforms and different approaches to the process of law in general. But the couple directions you could go is obviously group actions and collective work to put the resources in common and make it lighter weight for each of the institution. Work obviously with law firms and attorneys who are willing to engage in the cause and reduce their fees or not apply them. But yes, it is a structural issue in general. I don't have a magic wand on that one.
Let's try to connect with the next one just under, which is, as you may have seen, I think there have been a report on the supervisory fee from the Commission to the European Parliament recently, and it seemed that the European Commission failed to spend all the budget of supervisory fee last year. I think it was short, like it's collected by 15 million euros. If enforcement happens at national level and national courts, could this money be transferred to member states to strengthen the DSCs?
That is another great question, which theoretically should be answered by yes, but in the Treasury regulation and proceedings of the European institutions. I don't have the knowledge to tell you if it is legally possible because I don't know how really that portion would play out. But it seems like, I mean, from a political standpoint and a policy standpoint, if there is money that is not used for the enforcement by one of the enforcement players, it should naturally be directed towards the other enforcement players. This is definitely a political issue also of like who would get what and who would be the ones benefiting from this budget. Would they be the states that are currently the most active, which would be rewarding the good players, or would it be going to those who can't play because they don't have the capacity? That would be also rewarding those who have not actively engaged in enforcement. So, I mean, there's also a moral compass there to take into account.
Sure. Thank you, Christine. What's the current state of enforcement of the DSA with respect to AI technologies providers like Anthropic and OpenAI, particularly regarding dark patterns, opaque account suspensions, or content policies? Are we dealing with the same DSA? In that case, I'm not sure they have been designed as VLOPs.
So that is number one question. There is some talks, informal talks about the qualification of OpenAI as being a VLOP, but it has not been set by national courts or public or European institutions yet. All I can tell you is that the dark pattern approach is definitely at the core of the proceedings against X. So but X as a platform, not X as XAI or any AI platform specifically. But the regulation is converging. We've seen with the omnibus, obviously, the dark patterns and are coming into the AI regulation with the DFA most likely, but also the AI EU Act, EU AI Act. I'm sorry. Addresses the non-consensual contents as well and the deep fakes. So it's converging. Now, it has not been addressed directly, legally yet. Not to my knowledge. Well, I don't think so anyways.
Okay, so some space for advocacy. Next question is to go back to Article 40. You mentioned lack of powers if DSCs as a block to submitting Article 40 DSA data access request. But why is that the case when researchers can apply directly to DSC of establishment?
They can apply only in some instances directly to the DSA establishment. So there is still some lack of enforcement if there is no vetting power for the researchers by the DSC. And the local, I mean, the whole purpose of enforcement is also to make sure that the local coordinator, that the national coordinator is part of this and addressing the investigation process fully, participating in it. So it's kind of like bypassing a very important actor also of enforcement to just send the civil society directly to the establishment. Yeah. It would be a mistake to go into like encouraging civil society to just go directly to the establishment without having the coordination aspect of the coordinator.
Okay. Question about Working Group 4 at the Board of Digital Service Coordinators at the board. From where did you get the information that Working Group 4 should be focused on operational enforcement? I think you did not say that. I think you said it should be turned into operational enforcement.
Yes, and so the information I gathered ahead of this webinar is coming from both the civil society, the research organizations, member states representatives that I've been talking to, as much as European Commission representatives that I've been talking to. And it appears that Group 4 is currently used as a informational platform. There is some interaction, but it is not sufficiently used. It's a tool available to make sure that enforcement becomes more operational, actionable, operational, and collaborative. And right now, there's not enough interaction in the working group on the operational aspects of enforcement, sharing evidence, sharing experience on evidence collecting and applying.
Okay, thank you. Um, how do we ensure that all users, no matter the national court cases, have the same user experience within what is meant to be a single market?
Um,
Is that something, for instance, like if we could see that there are like difference of treatment of users based on their location, could something be triggered in terms of like any kind of international jurisdiction?
um, well, the question is interesting because I wonder if there's consensus over wanting this. I don't think everybody wants to have a global user experience and have all users have the same experience. I just don't know. From the industry perspective, I can tell you that everyone is resolving to the idea that there will not be a global governance framework and that it will be in silo and regional because there are too many cultural and conceptual disparities on the regulatory concepts. And from the user perspective, I think the same applies. I'm not sure everybody wants to have the same experience. But I do understand, however, the question in how do we make sure that, enforcement is of the same level, maybe in each country. Um, and that will resort again in either having a commission decision that applies broadly or having multiple national courts address it and converge on the way of addressing it. So far, the national courts have done, I mean, a good job of going in the same direction and having a consistent interpretation, but it's too early to say given the number of national court decisions we have so far.
Okay. Um, can national courts ever be accessible as long as abusive appeals designed to increase frictions, delays, and costs are possible? As in the Dutch case, should we have a sale, strategic appeals against legitimate enforcement?
Um, so again, great questions. Very structural questions, in fact, by the way, it's so this is interesting because it's not so much of addressing it in the tools we have, but looking at the tools we should have, which is also very interesting. Um, can national courts ever be accessible for as long as it? Well, it's a very tough answer to give because I think, of course, there should be some again some convergence in the way things are addressed, and there should be some commonalities, but well, this will result, I think, from the changes also in the guidelines that I've mentioned. I think if there is more clarity on what the commission wants to see addressed in the way it wants to be addressed, there will also be more clarity on the way it is enforced at the national level, and therefore some more strategic approach to it. But I again, I think I know everybody has been pushing for the DSA and working on the DSA for a very long time, but its enforcement is 3 years old to the max. We're still very early on, and there's a lot already out there to draw lessons from, but it's also a little early to actually slap hands.
Maybe one thing that could happen, because we know that we have this saying at EU DisinfoLab that the platforms will always appeal. When they lose, they will always appeal and they will always try to drag this more. But one of the questions is also to educate the judicial system about these techniques, which is also reflect the asymmetry, because on the other way around might not be possible. You might not be able to actually have the mean to appeal. And basically, like, if the harm continues, if the appeal is unfounded, we could also go and have this kind of push to say that appeals at some point are not here to reduce the overall fine or the overall infringement, but are also increasing the harm meanwhile. So that's
Yes,
also a complex strategy, and to say like, if you want to go to appeal, if you're going to go there, you're going to lose, and you might lose more.
yes, but if you look at the reality of the appeals today, and that was on one of my slides, the European Court, the General Court, has mostly gone in favor of the research, or actually of the Commission in this case. So I don't see right now a true signal of having to be careful because the platform's appeals are successful. I think the platform's appeals are going to be pretty widely, massively unsuccessful. And for the time, and this is what we're seeing. Again, 4 cases in. So what does that say? But for the time being, the approach seems to be pretty strict. And the also the kind of the, well, yes, I'll just stay to this for now.
Yeah, but at national court, we also saw, for instance, that in the appeal in the Netherlands with bits of freedom, like
Oh,
Meta
you mean in the national courts
withdrew.
also?
Yeah, Meta withdrew most of
Yeah.
the defense to only focus on procedural claims there. So that was also could be
Yes.
considered as an appeal that is actually not really an appeal, but just justified.
Yes. 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 But again, I don't see signals right now, really active signals that will be or it's not currently a problem. I don't think so.
Okay, last two questions. Given the recent Dutch case where Microsoft shared data of civil servants involved in the DSA under the US Cloud Act, how can we avoid exposure when EU bodies still use services instead of safe EU alternatives? More security oriented.
Well, we're touching upon the sovereignty question and how that can be put into play. Um, how can we avoid exposure when EU bodies still use US services? Well, it's a public procurement question of what the institutions actually use and how we preserve EU sovereignty over data and AI tools in general, or digital tools in general, I mean. What member states can do in this regard is to, again, collectively, because I don't think there will be an individual answer to this, but collectively support and participate in the effort of providing the EU institutions with EU sovereign tools. But for the time being, the dependence is what it is. I think we are at 42% dependence on the US services right now in Europe. So there's a lot of work to do. I think it's 47 even.
Okay. Quickly, Article 45, 46 relates to codes of conduct. What is the
Mm.
role in triggering an investigation by a DSC as per one of your slides? Does a DSC really have powers to compel an investigation? If I remember well, I think codes of conduct are a very peculiar enforcement line because you need to have board acknowledgement for code of conduct infringement, if I'm not mistaken.
So codes of conduct are, I mean, they're binding to a certain aspect, but obviously they are codes of conduct, so they're a directive. So, and as you say, Alexandre, a breach of code of conduct, I don't remember ever seeing one. I might be wrong, and I haven't seen it all, obviously, but no, I think it's very specific. That wouldn't really work.
Yeah, so not a road for enforcement. Last question. So we member states that are taking official positions encouraging the European Commission to better enforce the DSA. They could just send an official letter to the European Commission under Article 265 on the functioning of the Treaty of the Functioning of the Union, right? Uh, I remember
Absolutely.
I have seen some of these, big
Yes.
statements.
Absolutely, and that is what is most efficient,
Yeah,
clearly, because I don't believe Article 265 makes sense today again, within the DSA context. But I do believe that it is a call. It's there for a purpose. It is there to really sanction the institutions if they really go wrong. I don't think we're there. but it's there also to encourage member states to have that level of scrutiny on the institutions and gather information enough to bring attention to the European Commission officially, collectively, as mostly as possible, on some failures to act that are either established or likely to happen, to bring attention, to show scrutiny, just to show care.
Great. And last question from Sohan de Souza. Could the EU and ally country create an intermediary organization that serves a source and buffer for use by other researchers interested in the same assets request for Article 40 data?
Yes, so I think you will know more than I do, Alexandre, on this, but there are a few initiatives to try to create a central organization or structure or forum for researchers to put a lot of their efforts in common. And I think if there is such effort or new effort to be taken, it would be to focus on the quality of the legal processing of the application. So really addressing it with a lot of rigor and being very strict about how we approach it. And then the quality of evidence is the second part to put efforts on. And then, as I said, the last part, but that is crucial, is gathering lessons and information on the cases that didn't go through and being very proactive about building from mistakes or failures.
Great. Thank you, Christine. And we're going to close the Q&A here. Thanks a lot, Christine, for this very, very good webinar. I've personally enjoyed it a lot, and I hope it's the same with everybody else. We're going to close.
Thank you for having me.
Yes, we're going to close for today. We don't have any webinar next week. We have a webinar on evidence and enforcement, 25 of June, the DSA in court, DRI in Germany. We talked about it today. If you want to know everything about access to data and having access to data, I think that's perfect for Sohan's question. 25 June on this topic, 3 weeks from now. In 2 weeks, we'll be back to AI. Botnets to AI swarms, tracking emerging risks through AI Influence Observatory with Daniel Thilo-Schroeder at Sintef. Don't forget to take your tickets for Disinfo 2026. We'll have this conversation again with many more people in the room. And I can't wait, and all the team can't wait to see you all. Thanks again, Christine, for your time today. And it was very, very early in California. Thanks for the effort on that.
Thank you. Thank you. It was great. Thank you. I love all the questions. A lot of thinking to do for the future. Thank you.
Super. And we'll be in touch very soon. Thank you, everybody. Have a great day ahead. Bye-bye.